505 CF. And we passed the case so both parties could look on a sentencing point issue.
Yes, sir. Judge, I prepared 2 score sheets.
Okay.
So to the counsel, I did send her the one that shows 36.6 total sentencing points. The second one that I just now prepared showing 90.6 sentencing points, scoring moderate injury for 3 victims at 18 points per victim. That one comes out to a total of 46.95 months, which would still be within the range of the time the defendant has served heretofore. I'd like to present those to the court.
Okay.
Counsel says looking at them. Judge, we would argue that Ms. Parker, yes, she was acquitted on first-degree murder. She was acquitted on second-degree murder. She was acquitted on third-degree murder. She was acquitted on manslaughter. She was convicted of culpable negligence, which is a misdemeanor. The culpable negligence, she was convicted presumably as a principal. I don't know, either as a principal or as a principal in the first degree, but she was convicted of culpable negligence. Our position is during the commission of the culpable negligence, there was injury inflicted upon the victim. The court heard testimony about the injury. Mr. Whitaker had a broken hyoid bone. There were pictures that were admitted in evidence that showed injuries around his neck, made from a ligature. Miss Cox had a broken hyoid bone, and there were injuries of her neck. Miss Whitaker was suffocated. There was a picture. It was a contested picture, but it was in her that showed injuries to her nose and showed ligature marks to her hands, as well as I want to say around her neck. And Miss Cox, also there was testimony from the medical examiner, though we didn't have pictures of it, that there was evidence of blunt force to the back of Miss Cox's head, and that you can score injury points on principal theory. And that would be, for the record, 896 Southern 2nd, 873. I feel compelled to adopt young Master Cardenas's recommendation. And I also have an alternative recommendation for the court if the court exercises discretion not to impose his recommendation. Master Cardenas's recommendation was the maximum sentence. In this case, the maximum sentence is 15 years. And so I have to adopt his recommendation to the court. I've also prepared an alternative recommendation for the court. If the court wants to hear the alternative, I will propose an alternative as well.
Hunter, I want to hear anything you have to say.
Well, again, Judge, and I'm adopting Master Cardenas's recommendation, 15 years. If the court, certainly the court has wide discretion in the sentence. It's anything from approximately 47 months up to 15 years. I think anything in between there would be a legal sentence. If the court is disinclined to impose the exercise of discretion to not impose 15, the state will alternatively propose a sentence of no less than 8 years in prison, followed by 4 years on state probation. The defendant, as a condition of probation, would be allowed to return to her home state of Mississippi on supervision. I believe the interstate compact would allow that. As a special condition, she would undergo drug and alcohol assessments and follow any recommendations of the assessors. And undergo random drug and alcohol testing as a condition of the probation. I would ask that she be ordered to have no contact with the members of the Whitaker family, and that the court order to reserve on any and all restitution. Since this is a second-degree felony, I would ask that the court adjudicate her guilty of the offense. I don't believe that the evidence showed anything about this offense as being unsophisticated. This was a crime scene that was cleaned, Judge. It was cleaned up, and attempts were made to conceal the crime. This was a sophisticated crime, and this was something that the defendant admitted to assisting in. Clearly, the jury didn't buy the duress defense. If they had, she would have been not guilty on all counts?
I have considered the arguments, I have considered the evidence, I have certainly considered our jury's verdict. As to the misdemeanors, it's credit time served. The mandatory costs are imposed. I will order and reserve on the amount of any possible restitution. I will order no direct or indirect contact with the victim's family, and I sentence her to the 13 years Department of Corrections. Ms. Parker, you have the right to appeal the judgment and sentence of this court by filing a written notice of appeal within 30 days. Yes, ma'am.
We have costs.
Okay.
$43,805.31, so we ask that to reduce this objection.
Any objections?
No objection, no.
So ordered
$43,805.31.
and so reduced.
The defendant is adjudicated guilty, Your Honor?
Having been found guilty, thank you. Having been found guilty by a jury for years adjudicated as to all counts.
And the state would request the statutory under 943.325. I believe there's a mandatory DNA sample that would be required.
There is. I'm sorry.